All right, hi, and welcome back. Attorney Steve Vondran here. We are talking in this video about when should you file a lawsuit if you're going to file a lawsuit. So this video talks about, everybody says, they get really upset when something happens and they go, I want to sue this person. I want to sue them. And these are some of the common factors. I have, a checklist here with 6 what I call common things that you would consider, at least things that I would consider before I ever file a lawsuit as a business intellectual property real estate firm. So these are the important things to think about if you're a defendant, and sometimes people will wonder, I wonder if I'm going to get sued. These are probably the same factors that a plaintiff lawyer is going to be thinking about before they make a decision to sue you. So let's go over these real quick here and try to get a good understanding of the things to look at before you decide to pull the trigger, so to speak. Okay, number 1, do you have a case? The most important thing is, something happened to you, okay? Is it a big thing? Is it a trivial thing? Is it a real thing? Do the facts, number 1A, do the facts show that the equities are clearly in your favor? Now, as a plaintiff attorney, I like to see good facts. I want to see that I've got a good case. I don't want to end up getting in court a year later and find out that, I've got a bad witness. The facts aren't going to come out right. The equities aren't going to look like they're in my favor. You want to get a case that you can take all the way, that you can ride that pony across the finish line. Okay, so that's one of the things we're looking at, the equities of the case. Number B, can you meet all the required elements of your causes of action? Can you prove the elements of a tort? Can you show there's negligence? Can you prove there's financial elder abuse? Can you prove all the elements, 1, 2, 3, 4, of your causes of action? Copyright infringement, trademark infringement. Can you prove these? Do you have the evidence to meet each of the elements? If you don't, if you know you're going to fall short, as a plaintiff, you have the burden of proof by a preponderance of the evidence. If you know you're going to fall short, why go through all this? I mean, a lot of people may file suits going, oh, I'm just hoping for a settlement. I'm hoping for a settlement. But when you go up against big attorneys, or big firms, small firms, and you're seeking large dollar amounts, they're not just going to hand over cash. They're not just going to write you a check. You usually have to fight for that money. So you want to get something where you can meet the elements, you can take the pony across the finish line so that they're in the position where they go, they have to tell their clients, looks like the guy can take, he's gonna get past summary judgment. And because he's going to get past summary judgment, we might want to make a settlement offer. That's where you want to be. So I have a lot of videos on various causes of action. Can you meet the elements? Defamation. Those are the things you want to be able to be able to say, yes, I can meet the elements, okay? Number C, are you within the statute of limitations? What good is meeting all the elements if the claim is 3 years old or 4 years old? I've had people call me saying, something happened to me 5 years ago, 7 years ago. I go, probably not. That's probably not going to work. So timeliness of your lawsuit, okay? And number 1D, is there a better way to resolve? Now, a lot of people, like I said, they get all heated. They're just like, I want to start throwing punches and I want to sue them. And, I want an aggressive lawyer. I want a pit bull. You'll hear things like that. One of my questions is just take a deep breath. Is there a better way to resolve this? Can we make a deal? Can we offer a settlement? Can a lawyer make a phone call for you? Is there something that we can do that will get this thing resolved? So that's number 1. Do you have a case? Does it all make sense? Okay, you want to be able to check the boxes. Number 2, can you win? Can you win? Do you have good witnesses? Are you able to get some people to say, I saw the light was yellow. The light was yellow. I saw it. You have to have some good credible witnesses, not in every case. And sometimes you have circumstantial evidence that is overwhelming and meets the preponderance of the evidence. So, you don't always have to have, credible witnesses, but it's nice to. Anytime you have good witnesses that can support your case, the better. If you can have the Pope come in and the Pope is a key witness and swearing on the Bible, you probably got a pretty good case. B, do you have documentary evidence? This is the smoking gun. Do you have the smoking gun evidence? Something that you can hold up and say, here it is. Judge, I've got it, or to show the other party. So the witnesses, the documentary evidence, the circumstantial evidence. C, number 2C, experts. Some cases are technical. You're going to need experts. Is this a case where you can get a credible expert? Somebody that's really credible in the field as opposed to a gun for hire. Those are other things that you look at. So can you win? Do you have the proper evidence to get you over, admissible evidence to get you past that motion for summary judgment, past an initial motion to dismiss or demur as well? So there's different stages, but you always want to have that case where you know you can get it through, or you have a really good idea that through discovery you can find some of these things, you can find out some good witnesses, you can get some documents, but don't count on the other side handing you the keys to the castle and saying, here it is, here's the smoking gun for you. That doesn't happen very often. So number 2 is, can you win? You want to feel good about your chances of winning, putting all the players together. Number 3, this is one that I find most people don't think about, is the risk of a countersuit. Now, are you going into court with unclean hands? Have you heard that phrase, unclean hands? So you may end up filing a lawsuit and the defendant says, well, he owes me $20,000 that I never even collected. So I'm going to countersue them. They sue me, I'll sue them. And so I'll be seeking my damages. A countersuit is its own lawsuit. So the defendant gets to go after you just the same. And you may say at some point, oh, I'm going to drop my case. I'm going to drop my case. That doesn't mean they're dropping their case. They may not want to drop their case. You may have called, woke the sleeping dog or poke the bear, as we say, and now they want to go and take you all the way to a jury trial or to a bench trial. So think about countersuits. Is there something they have on you? Is there something they could get you? That's what we call proper pre-litigation planning. So that's why I have 3A. Do you have any skeletons in your closet? Number B, are you prepared to defend a countersuit? Again, costs and claims. You may have. You just need to consider: are you able to defend and pay for a countersuit? C, have you objectively and with a clear mind considered any defenses that they might be able to raise? Again, this is for you newer attorneys. Not only do you want to look and make sure you can meet the elements of the prima facie case, as we say, you want to be able to check the box on the elements. You want to have, number 2, the evidence to support it. But before you really make that decision, I'm going to file, baby, think about what defenses they may have available, because what good is it to get there only to lose on a defense? So you put all this time and money into your case, and then you trip on a statute of limitations, or you trip on a laches defense, or you trip on a assumption of the risk defense. Okay, so there's a lot of things that could happen. So with a clear mind, objectively, take a deep breath. Is there any way they could raise a defense? Is it a First Amendment defense? Is it a fair use defense? Is there something that can be raised? Okay, that's very key. So you want to feel good about number 3. You want to have weighed and evaluated that and say, I feel okay with that. Number 4, this is big, huge, as Donald Trump would say, huge. He would say, can you prove your losses? This is big. When people call, they'll call our office and say, well, I got a big case, it's a multi-million-dollar case. And I say, great, that sounds great. Let's go through the steps here, 1, 2, 3. Number 4, can we prove your losses? Do you have documentable evidence? 4A, can you document your losses? Do you have receipts? Can you show medical bills, hospital bills? Can you show financial losses if you're claiming business profits? Can you show loss of licensing fees if you're in a copyright infringement case? You need to be able to think about documenting, proving. Again, the plaintiff has the burden of proof, proving your monetary damages. Okay, and that goes hand in hand with 4B, as in biscuit. Are your damages speculative? Many times people will call, or I'll be reviewing the case and I'll just go, you know what, this is speculative. And it's going to be really hard to show exactly what the amount of damages are. Now, bear in mind, there's usually accountants out there, CPAs and other experts that can help you quantify your damages, and they're much better than I am at figuring out the nitty-gritties on how you can itemize your damages. And there's a whole slew of damages that could apply in any case, from financial damages to emotional damages, business profits, losses, loss of licensing fees, punitive damages. I mean, all kinds of things. So those are the questions you want to be able to ask. Can I prove that? Punitives, you don't so much prove. That's something that the jury determines if they see egregious behavior. They may hit a defendant with punitive damages. They may hit you as a plaintiff in a counterclaim. They may hit you with punitive damages. So that's why I say you want to think all this stuff through. Take some time. Take a Saturday and a Sunday. Think about it. Go through the steps. Make sure you're feeling comfortable about all of these sections. Number 5, collection ROI. What does that mean? Well, you may go through a case. You may have sued a plaintiff as a defendant as an individual. You may have also sued a corporation. You may have sued a DBA, a sole proprietor. So there's a lot of different things you can sue. But at the end of the day, if you get the judgment, the financial judgment, how are you going to collect that? Now, I'm going to have it here. 5A, judgment is not a guaranteed payday. Just because you get a judgment, $250,000, it does not mean that the money just arrives on your front porch in a bag. So you have to get it. Now, as I put here, 5C, do they have insurance? If you're dealing with an insurance company, sure, that's great. Maybe they'll have to write you a check, the insurance company. So those are nice. That's why a lot of plaintiff lawyers sue, people that are insured, or businesses where they feel that they're insured. And it's one of the questions you ask early on in a litigation when you're in discovery. Do you have any insurance to cover this event? So, that's really important. B, does defendant have assets? This is your corporation versus your individual, and doing an asset search. You can do an asset search early on in the case. It may cost you $300, $400, $500, $600, depending on the level and complexity that you want to do. But wouldn't you like to know if the person that you plan on fighting for a year has assets or not? That would be something nice to know. So you can do an asset search as part of the preliminary investigation to decide if you actually want to go after this party. Okay, it's very, very important, because once you get that judgment, you may hire a plaintiff lawyer. You may come to us and we get a judgment for you. But if it's an individual, then we have to say, well, now we've got the judgment, let's go enforce it. And now we have to go try to garnish wages. We have to see if they have any personal assets. Is there anything we can levy? Bank accounts, can we levy a bank account? Those kinds of things. But you want to know what you're dealing with. You want to be able to get your money, okay? So if you have to refer it out to a collection law firm, so say some firms will say, I'll get the judgment, but you're going to have to go out and hire a collection law firm. I'll take a lien on the case or whatever, but you're going to have to go get a collection law firm to collect the money. They may want a piece of the pie. So if you have $1 million judgment and your attorney says, well, I'm owed 30%, I'm owed $300,000 from the lawsuit, but you need to go collect, and you're going to have to pay some collection attorney 10, 15, 20%. Now you're out about 50%. Now there's only $500,000 to go after. And how long and how much work is that going to take to go after? So doing the collection ROI, return on investment, making sure the numbers add up, making sure it makes sense, getting a feel for what you're getting into is very, very important. So that's number 5. Number 6, I have some miscellaneous factors here before you decide, should I file a lawsuit? A, law of the press. Okay, many people don't think about that these days, but now it's become so important. You file a lawsuit. There's a thing called the Streisand effect, where you get all upset with somebody, and next thing you know, the whole internet's blowing up, and everyone's going, oh, she can't take a joke, oh my gosh. And so you want to be thinking about what I call the law of the press. How's this going to be perceived? Is the media going to pick it up? Do you have a case that could be benefited by the media or even hurt by the media? So you want to be thinking about that, okay? 6B, suing your customers. Now, sometimes you have customers and you have to make a decision. Do I want to sue my customers? They owe me $10,000. Should I file a suit? I don't know. Maybe they're good customers. Maybe you're better off keeping them around. It goes hand in hand with number C as in Charlie. Negative online reviews. Are people going to run around and say, you know, I'm a customer and look what these guys are doing. I can't believe it. They sued me. I was 2 months late on my payment. They're calling it breach of contract. You want to weigh all these things out in advance so that you can just, like I said, feel good about these factors. Number 6D, as in danger. Emotional costs. Now, I tell a lot of people, you know, you have to have not only sometimes the finances to litigate, but you also have to have the stomach to litigate. It means you have to be up for it because, you know, you have a full-time, let's say you have a job, some people have kids, spouses, significant others, busy lives, you know, all kinds of things going on. Do you want to add onto your plate a lawsuit and depositions and discovery and heartaches and mediations and, you know, those kinds of things? A lot of the things an attorney can appear for you and take care of those things, but are you emotionally ready to go through, you know, what could be a year, could be 2 years. Some lawsuits are 4 or 5 years. They go up on appeal and everything else. Are you willing to fight it through, up through an appeal? So these are the things that you need to think about, and that goes back to your ROI, you know, waiting 4 or 5 years, and goes back to number 1, is there maybe a better way to resolve? Okay. So emotional costs, and finally your attorney fees. If you have to pay fees, weighing in what you think you can recover versus what you think you're going to pay versus can you find a contingency lawyer, let's say. So this is not an exclusive list, but this is a good idea of kind of what lawyers think about, at least what we think about before we decide to take on a case. And I hope this has been helpful, but you know, again, if you need some help with litigation, you can find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. And we look forward to helping you. If you like this video, give us a like, thumbs up. That helps us a lot. We're on a push to get 1 million video views, so we appreciate everybody's support. We're at about 930,000 now. So we'd like to keep these videos coming out to educate the public. And as we like to say, make the law more understandable and accessible, not such a big spooky thing that everyone's afraid of, okay? It's dispute resolution, baby. That's what we're talking about. Attorney Steve Vondran here. Thank you for listening. This is general legal information only and not legal advice or a substitute for legal advice, advertisement, and communication. Have a great day. Have a great weekend. We will see you again on the other side, probably on Monday. Take care now.